check. 1, 2. Yep. Good morning.
I'm wearing shorts, a dress shirt, and a tie. I'm in the kitchen.
Who's ready? Mr. Neff, you want your client brought down?
Yes, sir. She may have already called. I need to call Andy also.
Good dream team. It's CBS. Donna.
Let's see what results.
I'm sure there's a better way. Is that what a former nurse?
What is going on with this poor girl?
No, the CBS shows, they have like a space. I have to go back. For the former. Yeah.
Didn't have any just rotated rooms and so a lot of the,
Always.
Wow, I didn't know. That's interesting.
but I don't have one.
Why
I don't
not?
have any documentation. He does hide on file. So I don't think anything on him. I can do that if you want, cause I don't. Do you have body cameras? Cause it doesn't say for sure.
Might be just for
Cigarette ball or something. All right. Go on there. Who do you have?
Randy Carey, our dog has her man. Randy Carey.
Alright, ma'am, I'll do that quickly.
Or good morning. We got Randy Carehart, case B 21-06025, and also B 21-01764. That's the community control violation. And representing Mr. Carehart.
No, I'm a new case.
All right, and on the community control violation.
Mike Trout.
All right, tell me what's going on.
Your Honor, I did receive some discovery today. I believe we're still waiting on one other thing, and other than that, I talked to the prosecutor. My client is not here today. He has a sick grandchild, and his grandfather's going to nursing home.
Now, these are two F5s.
Yes,
When do we start these cases? When did it originate?
The first, it looks like the DSC was January 5th
Okay,
of the new one.
with the new one. Okay. So what is your intention? We're gonna set it for trial?
Your Honor, we can, as soon as I can get the video that I need.
Okay. What is the drug of choice?
Judge, sorry, go ahead.
In the indictment, it's tramadol.
What is that?
It's a non-narcotic.
Okay. All right, so are you gonna set it for another clear trial setting, or are you gonna just set it for trial?
I can set it for trial if that's.
All right, let's set it for trial. Thank you.
Thank you.
And we'll continue the community control violation along with it.
Thank you.
Thank you.
I'll send you that one today, and I'll get you that Friday. Stole that, sorry.
Mr. Goldberg, you ready for your sentence there?
Yeah, I'm ready.
Okay.
Okay. With one place? Yeah.
Your name, sir?
Tyler Walker.
You look at-
Fine, Judge.
Are you ready on Tyler Walker? B 204405C, representing Mr. Walker today,
Brian Goldberg.
and on behalf of the state.
Kristen Heaton.
All right, so he entered a plea to failure to comply with the order or signal of a police officer and carrying a concealed weapon. The improper handling was dismissed, correct?
That's correct, Your
All
Honor.
right, have you had opportunity to read the PSI
I did, Judge.
mitigation?
Your Honor, in mitigation, I did file a sentencing memorandum in this case, just kind of laying out some things about Tyler, and providing the court some information on his background and what he is currently up to. Just for the record, just to reiterate a couple of things, he's 25 years of age, not married, no children. First contact with the criminal justice system from what I can see as an adult or a juvenile outside of some traffic matters. And he's just very, very remorseful for what happened here. He's accepted responsibility for what he did. He knows that his actions on this date were wrong. He was with a couple other people that he knows he should not have been hanging out with. I know one of them at least still has, I believe, charges pending before this court, and maybe some charges pending in federal court as well. But Tyler has really, this has been a wake-up call for him. He has completely, in my opinion, turned his life around. He now has a job as a forklift operator. He's making $19.50 an hour. He tells me he just recently signed a lease on his own apartment. So he really is trying to do the right thing. He has a good family support system in place. I did attach some paychecks to my sentencing memorandum showing that he's working full-time. In fact, most weeks it appears that he's actually working overtime. So he wants to put this behind him. He knows how serious these charges are and how much time he is potentially facing in prison. But respectfully, he would ask the court to give him an opportunity at community control. I do believe he will be an appropriate candidate.
Tell me about the chase.
Judge, it's my understanding it went for about a mile and he didn't really stop until the car did become undrivable. It was on Queen City Avenue. Yeah, it was about a mile that it went on before it became undrivable.
High rate of speed or?
Judge, the stop sticks did have to be utilized to flatten the tires. It doesn't indicate whether it was at a high rate of speed, but it did say that they did several attempts to stop the vehicle and he ignored all of the attempts.
As far as sentencing?
Judge, the state is asking for time on this matter. I know this has been going on for a fair amount of time, but in speaking with the police officers, they felt that time was appropriate, that the firearm was, I believe, registered to this individual as well as the fleeing from the police. We feel that this very these charges warrants some time to high permanent corrections.
Does he still have that open warrant for a misdemeanor traffic citation?
Is that here in Hamilton County?
Yes.
St. Bernard? Indicates it's probably still pending. So I don't believe it's taken care of it.
Okay.
But certainly that's something you can do.
Mr. Walker, what do you want to tell me?
Just want to let
Speak loud and clear so I hear you.
Just want to let you know that I was in the wrong place at the wrong time with the wrong group of people. I understand that I did do something wrong, that by not stopping. I'm working now. I'm trying to sign a new lease Friday. Got a lot going for myself. I don't want to do any time. I want to do probation, but it's all in your hands, Judge.
Tell me, why did you run?
I was nervous. They spiked the tires. I never had nothing like that happen to me in my life. I was, for the most part, scared.
Put a lot of lives in danger, you understand, when you run.
Yes, sir.
I see the only thing that's on your record is a lot of traffic charges. So you got a bad driving record, but no criminal record. This is your first contact with felony court, is that correct? You have a juvenile record?
No, sir.
Did you go over final comments?
Judge, nothing further. I will just add, I believe he did almost 2 weeks in jail before he posted bond. I have 12 days, so other than that, nothing else to add.
Mr. Walker, normally I give a prison sentence for running from the police because of the lives you put in danger. But considering that you do not have a record, that you do have employment now, you didn't have it when this first started, you have an apartment, you are doing better, you're showing that you're taking this very seriously. I am going to give you an opportunity on community control. So the sentence will be as follows: 12 days, credit to 12 days, you'll be on community control for 2 years. You must pay the court costs. Conditions of community control, you have to take a remedial driving course to make sure we teach you how to drive appropriately. Of course, stay out of trouble. If you come back before me on a violation, I could sentence you anywhere from 9 to 36 months in prison, you understand?
Sir.
All right, continue to work, continue to take care of your affairs. When you leave here, you need to report to probation immediately, you understand? Do you have any questions? Anything from the state?
Judge, we were just asking the firearms be forfeited. I don't know if he, I was not the prosecutor who took the plea, but I don't know if he pled the forfeiture specifications, but there were 3 of them that indicate that the firearms were utilized in count 3, which he did plead to.
Okay,
There's no objection.
all right. Firearm will be forfeited. You do have 30 days to appeal my decision. If you cannot afford the cost of the appeal or an attorney, the state will provide one for you. All right, where you headed when you leave here? Probation. All right, understand, again, I'm gonna repeat it. If you mess up on probation, I can send you anywhere from 9 to 36 months. And I will do it, you understand? All right. Good luck to you.
Thank you, Judge. Appreciate it.
Which one is that? You want to put it on the record?
I think
It's just plea negotiations.
This is Corey Freeman, correct?
Yeah.
You see, he's eligible for the
Yeah,
Okay.
but they were,
All right.
yeah.
All right. That's all you say. Yeah.
Well,
She's not.
that's what
I know, I just. No, our other case, the one, with athletes. That's not, no, it's not even close.
Yeah.
The one that's more private. Are you going to act
Sure.
You ready? Karen Jerusik,
Yes, sir.
this is B 206650. Representing Mr. Jerusik today,
Judge Carrie Neff, Mr. Joseph.
and on behalf of the state.
Andy Berghoff, Your Honor.
We are here for sentencing on one count of theft, is that correct?
Yes, sir.
That is an F5,
Yes, sir.
theft from her employer.
That's correct.
All right, Uptown Rental Properties, anybody here from Uptown Rentals?
Judge, I think they submitted a report to probation, victim impact statement.
I have it. Mitigation?
Judge, mitigation, first of all, I did read the pre-sentence report, the arresting officer statement, and the victim impact statement. Interestingly enough, the victim impact statement, they're not asking for restitution, which is around $4,000. Their goal is for you to make sure Mr. Rosick never does this again. And the only person that can control that is Mr. Rosick himself. So she has never been to prison. This is a low-level nonviolent offense. In the report, it shows a bunch of unresolved cases in Kentucky. Those have been resolved. That's why this case was delayed. She was in custody in Kentucky and then extradited over here. So those have all been resolved, and she is currently on probation in Kentucky, I think. Judge, I'm going to ask you to put her on probation in this case with whatever conditions you deem appropriate. Obviously, she's in a wheelchair again today, so the multiple sclerosis is worsening for her. She has a steady boyfriend. His name is John. I've been in contact with him. That's where she will go to stay in Kentucky. So we would also ask that you put her on community control, make her eligible for interstate compact, so she could be supervised in Kentucky and not have to travel over here when not necessary.
How is she gonna pay restitution? I know they're not asking for it, but how?
Yeah. Judge, I think you get SSD, Social Security. I don't know that she would be able to pay much back in increments, but over time, I guess that possibility exists. And then the only other thing I'll add is if the court puts any weight on the ORS score, the high risk assessment, she's low to moderate. None of the categories are high as far as her needs, so she's a low risk to reoffend. So really the issue here, I think, comes down to her ability to pay restitution. I know she has a willingness to do it, whether she'll have the ability over the next few years. We've seen.
Okay,
Thank you.
yes, sir.
Your Honor, I agree with Mr. Neff. I mean, her criminal history is not extensive. What it looks to me like is this is a situation where at some point in time she developed a drug problem. The drug problem led to a theft situation with her employer. It does look like from her recent contacts that she may need some drug treatment or some programs to address substance abuse issues with her. As far as the theft offense goes, it's a felony offense. The victim is entitled to restitution under Marcy's law. I have spoken with the victims in this case, and I have a dollar amount from my conversations with them that was shared with Mr. Neff in the reports. I cannot explain why they didn't put a dollar amount in the statement they provided as part of the PSI. And the conversations that I had with them, they were requesting restitution, and you can see from their statement that they indicated that they did suffer economic harm in the case. So I will still ask the court to oppose a restitution order. in the case, and the dollar amount that I have for the restitution is $5,434. That can be payable through a term of probation. We're not asking for incarceration either, but I do think a restitution order is appropriate.
Mr. Rusick, what do you want to say?
I'm really ashamed of what I've
I
done.
can't hear you.
I'm really ashamed of what I've done. I had a great employer and I took advantage of the situation. And it will never happen again, and I will pay restitution no matter how long it takes me to do it, because it was wrong. I have no problem making it right.
Mr. Neff, final comments?
Judge, nothing I can add, I don't think. Thank you.
All right, thank you. The sentence will be as follows. She's already served 26 days. So 26 days, credit to 26 days. She'll be on community control for 3 years. I'll remit the fine, remit the cost, remit the probation fees. I want her to focus on paying the restitution of $5,434. Alcohol and drug treatment as recommended by her community control officer. If I didn't say it, community control is 3 years. Did I say that?
Yes. Judge, I don't know if you need to mark it or not, but we can make her eligible for the interstate compact.
I will make her eligible. Anything further from state?
Bill,
I got I'm looking at that.
yes, no, not a good.
Anything further?
Thank you.
No. Mr. Rusick, you understand that if you violate the terms of your community control, I could send you to prison for up to 12 months for this charge. You have 30 days to appeal my decision. If you cannot afford the cost of the appeal or an attorney, the state will provide one for you. Do you have any questions? All right, once you are released today, you're going to go immediately to probation. All right, and then they will tell you how to get that transferred to consent.
Thank you.
Okay? Thank you. I'm done.
Town Rental Properties LLC.
That would have been my,
I'll provide the address.
that would have been my whole
If I would have been, now the prosecutor's taking along, the whole courtroom first, the judges. We were the dancing. No, but it's okay.
With those sweet moves forever and Catholic.
I sure.
It'll be posted somewhere in my office tomorrow.
I love a rag party.
Did we?
Yes.
Figure that out.
We figured it out. We just forgot.
Okay.
Good morning. Are you fine? That's fine.
Warming up the pipes.
Good morning.
We have the Basin Boys and Econ with both.
So are you gonna do a bond hearing today or no? No?
Did I have just another entry so that it's on your docket to combine them all together? There's
Okay.
Alicia, they call, we tried with the basic letters.
We are supposed to get some discoveries today,
We just got the murder book today, so we'll get you this.
and maybe after that.
All right, let's put this.
I've got a second Jocelyn delay, and it's not a voting case. But it could be one.
All right, so how many attorneys do I have on this?
Competent ones, Judge, or total?
Total.
Or including the state? We have shipped, 3 teams of 2, so 6 defense counsel.
Let's start with. Is it Alicia or Elisha? Marcus Akoff? Who's on Akoff?
I think that's James and Lisa.
Mr. Bogan,
Oh,
you
sorry.
ready?
Oh, I'm with the other than this.
Yeah, you with all of them.
Yes.
Yes, Ms. Urbanis just got walked in.
Okay. So you're representing ACOG, correct?
Yes, sir.
That's B 22000136.
Yes, and Ms. Urbanis is on it with me.
Okay,
Sorry, I didn't realize we're all on the record.
we are on the record. And then I have the other two. Make sure they're on my document. I know they got transferred from what other court?
Judge Branch,
Yes, Joseph Basil was originally on your document, sir.
Okay.
And that's 2106027. Keontae Basil was transferred from Judge Branch's, and that is B 2106457.
Thank you. And representing Joseph Basil
Kip Gannon, Doug Nicholas,
and on Keontae Basil.
Derek Gustafson, also Darren Isaac pointed on that, he's in Judge Hathaway's room at the moment, Your Honor, my understanding.
So you're all satisfied with the current bonds?
well, Your Honor, after we get some initial discovery, but nothing supplied yet, and I understand the state was just given the book today. We may be filing an appropriate motion after getting the initial discovery responses back.
Okay. And what are the charges, just for the record?
Judge, we have a series of aggravated murder, aggravated robbery, and felonious assaults for all three separately. Also, underlying robberies. Mr. Akoff also, unfortunately, has several weapons under his.
Okay. Where are we going from here? We just set another date?
Yes, Judge.
Waiting on discovery from the state, Your Honor, and then depending on what that provides, we may or may not file a motion for reduction of bond.
Okay.
maybe everyone's willing to wait time for next
Yes.
court date. Thank you.
So y'all have your books out? Do we have a date?
And I haven't taken yet, sir.
Let's see. See if we can come up with a date between 8 and
Selfishly, I'm in here on March 7th, so let's just set it.
March 7th works for me.
Let me see.
That could be available that morning, Your Honor.
You can be available that morning? So far we got
I can
4.
be available that morning too.
March 7th?
Yeah.
We're good. State March 7th is good?
Yes, Judge, it
Yes, sir.
works.
First,
So right now we have Alaman, one ACOG, and one Basil. We're waiting for one more case, one more to be transferred. Is that-
no, we should have them all.
No, ma'am.
We have them all.
Yep, we have them all, two Basils and one
Two
ACOG.
Basil, one Akoff.
And we're gonna try all 3 of these together?
Yes, they're same facts, same victim.
Okay.
That would be the plan, that would be the hope.
Do we have any witnesses here that were here?
I think the victim's family.
Person's family, but no one else. We
Oh.
believe, sir.
All right, they didn't want to speak at today's hearing. Just make sure I give them an opportunity so they know what's going on.
Well, we're not really approaching them about that,
Yeah.
sir.
Okay, but if they want to, they can.
Yeah, may I have just a moment, sir?
Yes, sir.
If I may, Judge?
Yes, you may.
So they are here, they are supportive of the case and say they will be here at every day. If in fact, there is a bond motion, they would like to speak at that, but at this point, they understand that we're going to exchange information and, hopefully move the ball on.
I just want them to know that the law requires that I give them an opportunity to speak at every hearing.
Yes, they're appreciated.
All right, thank you. Anything further?
No, Your Honor. Thank you.
Thanks.
We want to,
We'll get back to work on that discovery.
So I have one Basil.
Right.
I don't have counter, that's why.
He wasn't on. It's coming though.
That's what I'm saying.
We need an order from the Right.
I don't have a fiance yet.
It'll be here. It'll be here on 7th.
We're gonna.
You know?
Are you signing them? I will sign.
Yeah, I know you're good for it.
You're welcome.
When's the last time I had discovered exactly. When's the last time you ever thought about anything?
I'll fill them out. Thank you, I appreciate it.
Yeah, you know.
You heard from Mr. Bennett yet?
Nope.
I've got some video coming to me, just received a little bit of paperwork.
Just all this kind of
Anything else?
I'll see you.
Where's Mr. Moore?
Yeah, I need that one out, get off my one.
Did you send it a link? Did you send it? Okay. That's so cute.
Bless you. Good morning, sir. You want your client brought down?
Yes, sir.
I'm going to bring down Kendall Moore.
Miller.
Is it Moore? Miller. You're Moore. I'm sorry. I'm reading the document wrong.
Okay.
Yeah.
Mr. Bennett indicated anything? Send him a text. Did Mr. Goldberg handle Halloween? Keeping the date for Halloween?
Yeah. Sure.
Corey Freeman getting a date?
Yes. Does Halloween have anything to do with phase one?
No.
So Kendall Moore, we're just doing that all over back here again. Okay.
Yeah. You're gonna put it real quick. Thank you.
Mr. Trapp, what are we doing on Mr. Farley?
Well, he's residing in the River City, Judge, on street.
Okay, is he upstairs or is he?
Yeah, he's locked up.
You want to bring him down next?
Yeah, I think he's in line somewhere.
He's next after, Millis.
All time good.
No response from the defendant.
Not yet.
Jennifer Jones. Jennifer Jones.
Into the jury room. There's a lot of doors in here.
Forget, it's been a while.
I got a ESC. I was, I'm not been able to hear you yet. I just got transferred to state.
Actually, don't you have anything on her? Right, they didn't send you anything on that?
Well, the CNS,
Yeah, normally they send me a report, I don't know.
Okay. No. I'm away. Yes, actually. To be handy since I'm already just from here.
How are you all?
Catherine Bruce. If anything, it should be a minute job. It shouldn't be in.
So the 11 cases, obviously, you do.
Yes.
Thanks for it. So I went over to, I'll start going with that stuff.
Ms. Chess, you have another case? You guys have another one?
No, sir, I was just, this young lady, it's a little late, she was here yesterday. I didn't know if she was taking these. Washington District.
Morning, Mr. Bennett.
Good morning, Judge.
Oh, no.
Are you leaving?
Yeah, I got another one.
You don't have, this on?
No, she had to. She's got it.
I had it. Why? No trial? No, it's just one. Okay. Well, I'm not bringing it up. Yeah, what's that? Okay, nice.
We carpool to our sheriff's.
Yeah. I've been planning all year.
And every now and then.
You are correct.
What about you?
I don't know. Oh, you're trying to.
No. No.
Yeah. Great.
This is my first night.
Just go.
Yeah. No, but so later.
Oh, sorry.
So, yeah.
What else, mate? I got one of those. Well, I got a switch there.
They're bringing Kendall Miller over from the JCs to stop fighting.
Okay. Makes sense.
So we're waiting on the 200. That's what.
You still managed to step it up.
And then
Yes.
That's, that was just the one piece that was like, what?
Fantastic.
That's all I wanted.
I appreciate it. Judge, thank you very much.
We'll wait
Yes,
for-
sir.
We'll wait
Good.
for plus.
Yeah, I didn't, the camera has 30 pounds.
And how many pounds?
30 at least.
Okay, good, then I don't feel bad then.
At 30 pounds.
Barbara Collier.
Picture of what? Are you like? You're big.
You need to like.
You need to get that. Picture for the last time to take a look. How old are you? That was my thing. She did based on advertisement. That's pretty funny. It would have to be based on a lot. It would have to be based on. It is. Well, that's pretty funny. Mr. Moore, you're bringing Kendall Miller over from the JC.
Okay.
So, Mr. Chaps is on the way down.
Okay.
Scott Farley.
It really was.
Was it really?
Yeah.
What's up, my husband?
I'm like, how do you hear it?
It was just like that. I'm like, let this thing.
I've never noticed.
It would be fun so hard.
I thought the story. He just, they're still getting serious.
Yeah.
Apparently, wants to feel. Yeah, it turned out.
Like seriously.
Right. Every time.
That's right, yeah. Including, you know, the exhaustion and, necessary function with that.
Yeah, I'm gonna sit in the front row so I can see.
Right in the city. That's where, I think that's a wonderful place to go. Like, you'll help you with the other. We got other cases out. One, and I got all drugs and stuff, drug related. But you just live serious 4-6 one.
Yes.
Okay. I don't
And also you're gonna have to interact with All right, we already put out, right? Yeah, we already put out. This is just for something. Yeah. So how many days we got in there? Well, here, I'm not, 3 weeks. Did you do any fill-ins on here or there, or have you got time? Let's just run through the 1 day program. Yeah. But you're not better with shit. You feel better? That's good. Oh, get your thing, get you out of your stuff. I don't think there's a long wait for the city. I don't think it's very long. Okay, that's good. So there's not a very long wait. That's good.
You guys ready?
Yes, Judge.
So Scott Farley,
Yes, sir.
B 203536 and B 203536 count 2. Here on community sanction violation. Gonna waive probable cause.
We've already done that, Judge. Well, we put out the last time, and you got a River City referral.
Right, I didn't see it on the record.
Right. So we're here.
Make sure I cover my bases.
No problem. We're here for sentencing. My understanding is accepted in River City. Told me he wants to go there.
Yes, ma'am? Anything? Mr. Farley, anything you want to say?
I'm just ready to try to get back on track, get back to trying to be clean and sober, living a good life.
You understand that the River City program that I will put you in will be up to 6 months?
Yes, sir.
All right, the sentence on the community control violation, he's already served 79 days. I'll give him credit for the 79 days. I will restore and continue his community control with the additional requirement that he completes the 6-month River City treatment program. All other terms will remain the same. Anything further? Anything further, Mr. State?
Thank you, Your Honor.
All right, thank you. Good luck to you, sir.
Good. Yeah. Yeah. No, he's on probation. The thing is, he's gotta have that over your head. He's gotta have the marks on your head. Don't expect him to take out probation. Yeah, right. So you're still on probation. Now, here's the thing, you got these other cases. You gotta just try and work your way off probation on each one. I mean, if you do well, I would think that he would take it off probation. If you get to your city and you get the other cases, I would think you get your probation. But you have to show you're clean. You got all these other cases.
Yeah.
So the worst thing that happens is you just relapse.
Okay. Okay. I don't know if he's up there yet.
You gotta work on these cases. Probably be easier. I don't know. You gotta work to get on probation on these cases. I mean, you're still on probation, but if you don't relapse, you don't make sense. Yeah. We either have the probation transferred down here from other counties, or have this one that goes to there when you place on probation up there. But you're on probation up there, yeah, right?
Yes, sir.
We folks on.
Yes, sir.
Oh, no, we're closing. I went to walk on the door. I'm sorry.
Okay.
So we'll come down.
Okay. It is what it is.
Is Mr. Greenberger attorney? He was in here earlier, don't come down here, let's see, stop back on.
Doesn't matter. Whoever is ready. Bring them on in.
Let me see, what do you want? Learning things?
New cases.
No way.
Judge. Your Honor, my question.
Yes, go ahead.
One of the cases I intend to cite to in Mr. Miller's hearing today is Mohammed versus Eccleberry. I didn't know if you were familiar with it. So
Okay. Thank you. Okay, so you guys here on? Kendall Miller, sir. Okay. I think he's on his way down. Yes, sir. He's next. Kendall Miller next.
they're bringing it over for the Justice Center at one point.
They're still working on that.
Yeah.
Oh, so he hasn't made it over here yet?
They're working on it.
I'm ready to do Overson. You don't understand both guys. Did you guys?
You ready to do Overson?
We are, Your Honor.
He's here?
Well, it's on his way down, or it's going to be brought down.
Oh, he's upstairs as well. So I have 3 waiting to be brought down.
I think they're probably gonna bring class
Okay.
Someone else. What's that? So that was my specification. So I asked, I had that same question. I asked, I asked. Just, yeah. Yeah, so I got the manual or something. It's, video. And then, when I was extension, signing the document, so. That sounded good. Because my guy was holding out for 3. Trying the opportunity to ask for 3. Was worried. And then was, well, you know, below that, but most times for 5.
Okay.
Front row, second seat.
Jackson? Orlando?
Hold on.
Yeah, we asked for 2 other ones and
Right.
we got Mr.
Yeah, I got up there, they're like, they called and they want a different one.
Okay.
Okay.
I do.
All right, this is Orlando Jackson, case number B2104-104, B2104-964. 2 counts of aggravated robbery on the first indictment, 2 counts of robbery on the first indictment, on second indictment, 3 counts of aggravated robbery and 3 counts of robbery. We're here for a bond hearing.
That's correct, Your Honor.
Yes, sir.
Judge, I respectfully request the court to reduce the monetary bond in this case to $50,000 on the grounds that we look at the rules, not the rules, but we look at the factors that are set forth in Rule 46 of the Ohio Rules of Criminal Procedure. I think the bond should be lower than what it is.
You said it's at 50,000 now, is that straight? Or
No,
is
I'm
that-
asking for 40 to 50,000. I think right now you're 140,000, 200,000.
I believe it's 10,000 straight on the middle.
No, the total bond, I believe, is 200,000.
That was it. That was the first one at 10%.
That's all right, I'll get. These were the bonds set by the magistrate, correct?
Yes, Your Honor.
Go ahead, I'm listening.
Number one, at the time of the offense, I don't believe he was under probation, parole, or any other limitation or restriction by the government, any type of supervision or monitoring by the government at the time of the alleged offenses. He lived in Cincinnati, Hamilton County all his entire life. He's got strong family ties. His family's hired counsel. And I think the evidence is not the strongest that I've seen.
These cases go back to August of last year, correct?
That's correct, Your Honor.
And he's been in the entire time?
Yes, Your Honor.
The case ending in 104, I have 200,000 at 10% plus EMD. Give me a second on the other one.
The other was 10,000.
I'm just telling you.
Judge, the other thing I point out would be his lack of a criminal record. And I don't think he has a case or one.
And the other case that ends in 6-4 is the 10th Street.
All right.
The last one that I have.
Mr. Bennett, anything else before I ask some questions?
No, Your Honor.
All right, so 21-041-04 is 200,000 at 10. And then 21-049-64 is 10,000 straight.
That's correct.
What are his current assets? Does he have any?
None, Your Honor. He's been in jail for the last year. His family hired him. He did not use those. Of course, we have the attorney-client relationship, the phone with the children, with family members. He doesn't have any assets.
All right. I know he's not working now, but was he working prior to being incarcerated?
I don't know that. In what capacity? Because he was employed prior to being arrested. He was doing janitorial work.
Okay. Who does he live with?
His mother.
He's been in Cincinnati his whole life?
Yes, Your Honor.
What are the allegations?
Judge, the allegations are that these are roughly some of 14 robberies that were set up on Facebook. The allegations were that the individual had set up a buy for an iPhone, for instance, usually with victims who have some sort of a language barrier. They all alleged that they were robbed with a black 9mm firearm that was kept in the fanny pack that was consistent with nearly all of the victims. The officer is present in court today. She is actually one of the victims. They had to set up a sting in order to catch Mr. Jackson. There was also phone warrants that were done, as well as, I believe, identification was under photo, right? Is that correct? And she can speak to more of the allegations as well, Judge. I believe this went on. The earliest that I have charged is April of 2020, up until the end of the summer, and they were all believed to be related. It would take place in the Bond Hill area of Cincinnati.
Yes, ma'am. Tell me your name for the record.
Detective Corey Dawson.
Go ahead.
Pretty much consistent with what she said. These all took place over the span. They started about in April and ended in August. They all had consistent MOs, consistent victims were targeted. Most of the victims did have language barriers, firearms used. One victim was pistol whipped. Another victim tried to grab the firearm from the suspect and the gun went off. The victim did sustain an injury to his hand, unknown if it was from the actual bullet or the gun itself. So. Pretty
Okay.
serious.
All right, so I'm looking at his record. He has a pretty lengthy record. He was convicted in 2020 of aggravated burglary. A lot of misdemeanors, plus these pending charges. So you've been in prison before, correct?
No, sir.
All right, what was that sentence on your burglary charge?
Trespass. I got out and I was on the box. That was a juvenile.
No, this is back in 20. No?
No.
Judge, I have a 2020 F4 receiving stolen property adjudication at a juvenile.
Okay.
Yeah.
Anything else, Mr. Bennett?
Nothing, Your Honor.
All right, based on what I've heard this morning, the bond appear to be very reasonable. On the 4104, he can be released on 20,000, and on the 4964, he can be released on 10,000. I think those are very reasonable bonds, so they will remain the same.
Thank you.
All right, thank you.
Very sure. Yeah, the paper.
Yeah, do you have everything?
I don't have it.
Or we want to still for you?
I'm actually good.
Okay.
They don't have it for you yet. They'll call you and let you know. You can call me.
Or how do you?
I have other people to bring now. They're not gonna not tell you.
One day.
That's just for clear trial, sir?
Yes, Your Honor. It's a lot of discovery. I have to be called.
He's been out there for a while.
I'm sorry, Your Honor.
Haven't they been out here for a while?
I just got hired.
Yeah. I mean, they started back in August, correct? I think his first appearance here was in September. Is there another attorney on for you?
Yes.
Okay.
Herbert.
Herbert, so this is the one from last week, I guess.
Yeah.
Thank you.
Sorry to fire her.
Yes.
Fairly recently. Now. Okay, I'll send it over to him. Okay. I forgot your number for a second.
I think it's safe to assume you're not gonna come on that.
Yes, they're not, so I can just.
So we go with that.
Yeah, last time that's what I had, that,
It's not a-
offered.
Well,
I like that.
I work in the veterinary.
It is great.
What are you doing back?
Still need a date on.
Thank you for your patience, Mr. Carter.
This is live right now. We're gonna do one reenactment for the judge.
I got the double button.
Awesome.
Mr. Moore, did you hear that?
Yeah.
They're gonna, I think it would aid the judge in making his bond.
Okay, so what do you
He
want?
was able to actually physically see the application. So the detective is gonna take off his shoes, and sit up there and do it.
Okay.
I think you like the future, like general lights. Not the flash.
I mean, I'll figure it, right, but I'll be staggered, I'm just.
She called me and there was something on the, the other thing is.
Oh, either they want to settle or they don't.
We didn't- we were-
At this point, like, I don't know.
Like, one after the other, like several weeks in a row. Dave, you call me next week. I'm gonna be out of town. This Saturday. So if you don't get it, call me right away.
Okay, I'm back with we have.
Yeah, but just so you know, if I don't respond right away,
That's fine.
just ring my.
I appreciate that. Okay.
Yeah.
I understand.
So, okay, well, that.
So otherwise it might be a trial, so.
Sounds great.
Yeah.
Did the attorney come
He's supposed to be-
once you get the date, or is it set out?
We did an argument on the record and they did communicate March the
I did.
22nd.
I mean, I'd like to sit there, but.
Will you subpoena your, witnesses for that day?
Probably not now.
March.
Okay. Couple weeks.
I don't know what we're talking about.
Okay, you're on TV.
Did you have to meet one of them?
Oh, this.
Yeah.
That's why I was in there. Yeah.
There's somebody.
Show somebody else and give you all the time.
I think there was a team.
To do what? The body cam? Yeah.
Oh, it is? That's fine.
It does. I told you it's too long. That's not right. No, I said that's.
Oh, you misunderstood his question.
What you phrased the question off.
All right, so that's what.
That's too soon. I'm just kidding. Yeah.
Thanks.
Oh, he's.
You want to keep it on? The reason we can't.
I hope he's gonna sound fun.
You want to keep it on the 16th.
Why don't you two just let me know?
Yeah, we can do that.
Should I file under, should I file under mom on this?
Yeah.
Yep. That's fine.
That makes more sense.
Who's your detective?
issues. I don't hear victims kind of shape.
So that makes it fair game.
Yeah. And it's like presumption. I don't know.
Okay.
I mean, I think he's from out of town, but I guess he's living here now. You missed that bench trial, so you showed up.
Do you have what you want to do? And I'll be ready.
I'll send it. Clear. That's good. Yeah. I'll shoot it.
For Alan, yes.
You know, me?
Thank you.
Yeah. He's already left.
You too. We'll see you.
I heard back from a guy after hours yesterday.
Oh, yeah.
No, that's fine. He was working.
Oh, you're fine.
No, that's good. We were originally sent for, Monday the 14th. Mr. Boyce said we can, he would be okay with me.
I know he was presented.
Yeah, I'm just wondering, because of when we have to keep it where it is on the English schedule. I am. Yeah, I know. He only has one bed there, and he said it's in and you can see what it is right there. Well, I know, they're moving it later.
Front row, second
I could do probably 17, 18. I heard you say something about the dead one. Yeah, if you wanted to put. Okay. Um, 17, 18.
What is this for?
I'm strong. You're sentencing today.
No.
Of course he is.
That's what we were going to do.
I don't know, so you don't have to worry about it. I'm like, holy smokes.
But we need to find out. No, I am sorry.
But yeah, we'll say, no, if there is, it'll be in here. Oh, come on, let me. Enough to know that anything I have for you guys goes in this magical tray. It's like where all the reports live.
I know.
Yeah.
I wasn't even in here, so they just had, they called about moving the court date, so. I have stuff in here first. Not with you.
That's good.
I don't think the last time we had something, the last 10 days, the first time they closed the second one.
You won.
Well, he's having a bad day.
I kept out the picture.
Because it wasn't relevant.
Oh, very relevant.
I did.
No, I think it was bigger as an alibi. Well,
Oh, no, like 22. No, it had to be like
it was, the daily offense.
what year?
So we can.
Very good.
And that bar with the shit.
I'm still waiting on the alarm. I'm like, it's weird.
Oh, yeah.
And then that'll be the last one. Yeah.
Well, no way.
I didn't hear anything. What did I miss?
No, that was, they changed their office.
Oh, you guys did?
No.
Yeah.
So there was about 6 of us.
See ya.
Oh my goodness.
Yeah.
Yes.
All right, this is Kendall Miller.
Your Honor, this is the law oversight.
You guys are bringing down the wrong.
I was on the one too, Judge, sorry.
So Kendall Miller was next on the list.
Yes.
You got a 50-50 shot.
I had a 50-50 shot, I know. It's like, nothing is going right today at all. Good morning, sir. You are Lamont Overson. B 21-02968, here for sentencing on one count of trafficking and cocaine, a felony of the first degree, correct?
Yes, Your Honor. Oh, do we,
What's that?
nothing. Nothing, Judge. I was expecting to see a court reporter there instead of one right there.
Oh,
Yeah. Sorry.
all right, mitigation.
By way of mitigation, Your Honor, first just want to tell you a little bit about the defendant. He is a lifelong Cincinnati resident, Princeton grad. He's got 4 kids, ages, I think, almost 30 to 17. He does have, he's a mechanic, so what he doesn't do is he the body shop before he came in here. As it stands, Judge, he's pled guilty to trafficking in the first degree, which means that he has to be sentenced to prison, and it has to be from between a 3 to 11 year definite sentence, and with a 1.5 to, I believe, 5.5 years of variable time for Reagan Totes. As a result, Judge, what the defendant's asking you for today is a 3-year sentence in prison with definite time. My understanding from speaking with the state is that they will be asking for 5 years in prison. Obviously, nothing binds the court to either of those numbers, but we are hoping that you'll at least minimum go no higher than what the state is asking for. How we got here, Judge, is pretty simple. The defendant was trafficking in controlled substances, cocaine specifically. He sold to a informant who then a search warrant was obtained, his house was searched, and the cocaine in question was recovered. The defendant has not, he's at no point maintained that he's innocent or that he's somehow wrongfully caught. He was just doing something that he wasn't supposed to do, and now he is owning up to that fact.
So let me ask this. Back in 2009, he was also convicted of trafficking in cocaine, correct?
Yes, Judge.
How many years did he serve on that one?
So the 2009 sentence, he did 8 months on that. It was on a probation violation. I asked him why, and he indicated that it was he had fallen behind on basically he missed a child support hearing, and they violated him, and then he was sent for 8 months on that case. He has, however, completed the total of that I counted, I think, 3 prior trafficking convictions. To the 4th. From 2000, 2009, 2017, and was it more than one count maybe on one of those cases, or is it missing a date?
There's 2 counts on
Okay.
2000.
Yeah, so in any case, he completed probation on that 2000 count. Looks like they terminated him, didn't put successful on his entry because he owed $151 in costs, but otherwise he stayed out of trouble for the 3 years that he was on probation for that one. And in 2017 case, he was terminated early from probation in 2018 for just as successful on the entry. So he did well, responds well to probation, at least in the sense that he's 2 out of 3, which is, to be fair, a lot better than many of the people who come through the courthouse. Doesn't have much else on his record. He's not a violent person. He doesn't hurt people. No robberies, no burglaries, no felonious assaults, anything like that. It's just he does sell drugs, and so that's what he's here for. What caused the most recent foray into drug trafficking is that he was falling behind again on child support and other bills and expenses, and was trying to figure out a way to pay all those off. And
So instead of going out and getting a legitimate job, he decides to sell cocaine.
That's
Because here's the history, 2000, then 9 years later, he gets caught again. And then 8 years later, he gets caught again. And now here we are, 4 to 5 years later, he gets caught again.
yeah, I mean, those are the facts, Judge. It's not something that I can I can wish away with any sort of words. It's just that is what it is. But what I would point out are a couple of things. First, the amount of time that he faces, even if the court does give him 3 years as opposed to 5 or even 11, will be the most amount of time that he has spent in prison by far. Again, the last time he was in prison was for 8 months. So it will be a significant increase in penalty that he's faced. As it stands today, he's done 243 days, but that's neither here nor there. As it relates to the sentencing factors under the revised code, none of the aggravating factors are present under 2912B. At the end of the day, this is a nonviolent drug offense. His mitigating factors, again, no one was hurt, no physical harm to persons or property. And one thing I did want to point out to you, Judge, what I thought was kind of remarkable, is that when they searched his house, no weapons were found, which, I mean, I think is kind of surprising, given the nature of what he was doing, and the prevalence of firearms in that trade. But that goes to, I think, reinforce what I've said before, is that the defendant is fundamentally a nonviolent person. As it relates to risk of recidivism, Judge, I saw the ORES score in the, or the ORES risk factors in the PSI. And I did have some issues with them. I note that it's moderate or low, with one that's, so it's mostly moderate. There's a low and a high score. The high score is something that I'm sure the court's aware of, but just I do want to point it out just in case. I think it's a little unfair for the defendant to have a high score in the neighborhood, was it neighborhood factors or something of that nature. But that seems to me is, I can't think of a sentencing factor that would be more geared to punish African Americans as a class in looking at their neighborhood as a reason that they should be going to prison. It's just whatever historical factors and everything that this court is more than well aware of. That just, it seems a little bit unfair as a factor to be going after people for. And I also didn't understand why he was giving moderate substance abuse score when he indicated in his PSI that he does not have a problem, hasn't used. And it was marijuana. He's also getting a little older, Judge, and he's reaching that period of time where he basically moved beyond when most people commit crimes, and he's getting to that age.
How old is he?
48. And so he'll be coming back at a minimum in his 50s. And at the end of the day, Judge, those are the facts. He was dealing drugs. He got caught. And he's pled guilty.
Was there any fentanyl?
It was all cocaine with minus.
Just making sure it wasn't laced with fentanyl. Yes, ma'am.
Judge, we feel that 5 years is an appropriate sentence for this defendant. As stated by yourself, he has 4 prior trafficking in cocaine convictions. And when the officers went and did the search warrant on his home, they found over $7,000, 4 digital scales, as well as over 120 grams of cocaine, all individually wrapped. It qualified for the MDO specification, but that specification was not checked and put into the indictment. So he caught a huge break there. It qualified. He could have been charged with the MDO. We feel that this shows that time and time again, he comes back to this trafficking in cocaine. And like you said, he could have gone out and gotten a job. He could have done something else, but here he is.
Let me ask this question. This is very intriguing. we confiscated $7,000. Can that be turned over to child support?
Right now, I think the state has filed a forfeiture action to take that.
Right, I understand,
Yeah, I
but that goes to something else. That
Yeah.
won't go to paying his back child support.
I don't know, I mean, I guess that would be up to the government once they seize it, what to do with it. I don't know, they presumably could. Or go buy more, police cruisers.
I mean, if he was doing this to pay his child support, he might as well take that money to pay his child support.
I think that's a great idea.
I might just put it in my order and see what happens. Go ahead.
Judge, I have nothing to add.
Okay. Mr. Overson, anything you want to say? A couple of things that are going well for you. The fact that you're not violent. You didn't have any weapons. Those are good things for you. The other thing is that while you're selling drugs, you're not selling the drugs that are killing people. You understand? It's still bad, but you're not selling the fentanyl laced products. You understand? I don't want you to sell anything, but you're not selling that. So those things are in your favor, but you're still a drug dealer. You understand? So that's still bad. All right, the sentence will be follows. I am going to give you the minimum sentence only because you're subject to an additional 1.5 years that could be imposed by the Department of Corrections, not by this court. I can't overturn it. I can't do anything about it. They are the only ones that have the authority to give you that additional 1.5 years. So 3 years in the Ohio Department of Corrections, subject to the Reagan-Tokes additional 1.5 years. There's a mandatory fine of $10,000 plus court costs. He gets credit for 244 days that he served.
243 is it today?
I have
We have
44.
Well,
we
we'll
have
take
244.
44, I won't argue on that.
Once he is released, he will have to serve a period of post-release control. He understands that, right? You get over that with him.
I did.
Anything further from the state?
No, Judge.
I'm going to order the $7,000 to be forfeited and paid to Child Support Enforcement Agency. We'll see how far that goes. Pay for his back child support. Anything else we need to forfeit?
I don't believe so, no, Judge.
Mr. Overson, anything else you want to say? Go, sir. You have 30 days to appeal my decision. If you cannot afford the cost of the appeal or an attorney, the state will provide one for you. Anything further? Thank you.
Yeah, hopefully that they're gonna know about. How? I've been going in and out the door all morning.
No idea.
I've been going in and out the door all day.
Did you get the know about that?
Yeah, it's definitely locked. You must have locked it when you closed it. The last time.
Yeah, sure. Uh-huh. Apparently I'm not. Some 6 weeks or so.
Stop. What are you waiting on, Mr. Moore? You're gonna wear a hole in the car.
Yeah. This guy's been, another guy's just come down.
Uh-oh.
Then I got Oyster, what's in upstairs for jury. Marsh also.
Marsh isn't here today.
She's not here today?
She like broke her arm.
Oh, what?
She slipped and fell. You don't know this?
This is the first I've heard.
No one's had it during March today.
Are you kidding?
No,
No, I can never tell it.
who's on your text thread? Reach out to
That would be a
your
little
friends.
harsh.
I don't know if she broke her arm. No, she slipped and she fell and she's not coming to work today.
Okay.
Sometimes.
What's that?
Oh, so that lot on your plate. Oh, Miss Howard isn't hot on your trail?
Well, she is too. She takes me about 9 to 10. Watching there.
Oh.
Get better. And I'm trying. You guys get out of here.
No, it's Kristen's birthday. That's an announcement you. A 100% vice principal in the jury. They just set for trial. It was terrible. Yeah. I was the one probably.
You know the rule of thumb. That was like after 50 years.
How did you drive together? You wanted a burger? You should have rode a bike here. Well, my judge is not,
So the one in Essex.
Oh, yeah. That woman is for real. She's coming back. I was like, oh, you went to trial? I'm in the judge right here.
Allison, you don't have to wait for me.
Well, I didn't realize can take all day.
Well, no, it's just that they're, Mr. Moore's gotta bring everybody down in their van, and so it's taking a while.
We got one left.
I thought of something for you, Allison.
What, did you guys know it's Kristen's 30th birthday?
It's not my 30th birthday.
It's 30th.
30.
29.
Yeah.
29.
Is it really her birthday? Yes, and her parents were watching the YouTube. Why would you not tell us that you?
That's because my parents have nothing better to do.
Wait, is that?
They're supposed to be watching my kid. I don't know what they're doing.
They're not watching your kids.
No, they were like, silence, he feels like Chelsea.
What?
The other day, my dad thought I was Allison.
Wait, is the sound?
Yeah, I think so. Hi, Mr. Schmidt. I don't know that they're still watching. They probably got bored by now.
Yeah. Yes, yes. So I was coming to collect her so we can go to lunch. But I'm definitely not sitting.
Detective.
He's gonna do a reenactment. Did you hear? A reenactment of the crime?
Yes,
Just of the toe tickling.
yes.
Her husband's adorable. Have you seen it?
No,
And he's such a good husband to her. Usually.
He would probably won't. Well, he might go for it. I gotta write. Oh, they are watching. They just text me.
We are facing.
Very, well, you guys know. No.
Can't forget we're on TV. I keep trying to say
Me too, yeah,
Okay, well,
I keep trying.
there's a lot of justice happening here.
I gotta go.
Wow.
See, now she's embarrassed because she's on TV. And then I don't know if Greenberg's ever coming back.
I saw him
Where'd
leaving.
that lady go?
Wait, so I read that these were losing on your. And did you do this yourself? Yeah, what is it? They monogrammed.
James, this is a hearing.
Yeah.
Not other
It's just your
Gotcha.
Oh, you definitely know.
Nobody else does.
Did you have amendments for these two? Karen, for us,
I gave you,
Breckenridge?
I don't have a recommend, and I gave you Karen hers.
All right,
I have one more.
thank you, ma'am.
Like the guys. Got it.
Yeah, that's what.
This one, sugar? Yeah, here. It's not, they don't take sugar because it's zero sugar,
Oh, that's fine.
but it's like room temp take sugar. You broke that so I didn't hear you out of my own. And what exactly is that? Is it like a one-day thing?
All right, sorry about that. This is my last lockup. Do I have the right one this time? I had a 1 in 3 shot. All right. We were playing Hollywood. Right. So this is Kendall Miller. B 21044008. And representing Mr. Miller today.
James Moore.
And on behalf of the state.
Kristen Keeper for the state judge. I have Detective Bell from the Cincinnati Police Department.
All right, thank you. Tell me about this case. This was a burglary.
Judge, this was a burglary. The victim woke up in the middle of the night to the defendant inside of her apartment, fondling her feet. So then she woke up, it startled the defendant, and he fled through the window and left his shoes by the floor. I believe that he resides in the same apartment complex as her, same apartment building as her, his mother does at least. And I
So,
believe
hold
that's where
on.
he stays.
He goes into her apartment, takes off his shoes, leaves them in the room. She wakes up and he's fondling her feet.
Yes,
How did he get in? Allegedly.
through the bedroom window, Judge. As you know, Judge, he's also on community control for a burglary as well as drugs to you from last year. The victim is not here today, Judge. She did contact our office. She would be in opposition to any reduction in the bond. She is terrified of the defendant getting out. She has made that clear to us every time we talk with her, but she could not be here today.
Okay. I believe we already had one bond hearing. Is that correct?
Yes, Your Honor.
And the victim was here at that bond hearing. What is the current bond?
100,000 and 10%.
Okay. Yes, sir. Go ahead.
Judge, what we're asking the court for is to reduce the defendant's bond. He cannot make the current bond. Obviously, he's still here, but he simply cannot make it. No, just to clear this up, I think some record-keeping issues. No probation violation has been filed because he was placed on probation on August 24th. The alleged offense date is August 1st of 2021.
So you're telling me that the alleged date is before placing on probation?
Correct.
Okay.
Judge, so, of course, the Supreme Court recently decided with DeVos, clarified some of the ways we've been doing things in the past. And what the basis of the basic argument was that when his bond was initially set at 100,000, 10%, sort of the safety of the community was one of the factors considered by the court when setting his bond. That's not permissible any longer.
Right. So you're telling me that the Supreme Court has mandated that I not consider the safety of the community as a factor in setting his bond?
As a financial condition, for the financial conditions of the bond. You can certainly consider it in terms of setting other conditions such as EMP lockdown or something of that nature.
Right.
Additionally, Judge, what the court in DuBose did say was that the factors the court could consider were the risk of his non-appearance, the seriousness of the offense and his previous criminal record. And all of that was to be considered within the, I guess, view of any financial conditions and quoting from the rule.
So let's just cut to the
Yeah,
chase.
yeah.
I have to consider his means when setting the financial portion of the bond,
Yes,
correct?
correct.
What assets does he
None,
have?
none, Judge. He was, he had nothing when he, the financial affidavit that he filed with our office when he was appointed counsel indicates he had no income at the time he was taken into custody.
Right.
And certainly that has not.
What family support does he have?
So you know how much family support do you have that can make a bond for you?
My mom, my sister, maybe.
Maybe. So you're telling me the only bond that I could set based on the Supreme Court mandate is a zero bond because he has no money and no means to pay a bond.
I don't think the Supreme Court goes that far in what it says, Judge, so I wouldn't say that.
Well, what they say is if I set a bond that's high to where he cannot pay it, that's equivalent to setting a no bond.
That is correct, yes.
So if I say $1,000 and he can't pay it, that's still a no bond because he still can't afford $1,000.
You could look at it that way.
So no matter what I set over zero, he can say I can't afford to pay it. And then I would be in violation of the Supreme Court's recent case ruling, correct?
Yes, Judge.
So anybody could come in and say, I have no money, I have no job, I have no family support, they could post my bond. So you're required to give me an OR bond.
I think, Judge, that the consideration there would be that, is he telling the truth? So for example, I know in one of the cases that I was intending to cite today, Muhammad versus Echoberry, which I believe is 162 Ohio State 3rd 583. This sort of compared and contrasted how that sort of application would apply between that case and another one in which the other gentleman could make had some financial means and could make $1 million bond. I think they actually appointed a special master to look into his financial situation in the Muhammad case, coming up with that he didn't have much money, and they set the bond at $200,000 at 10% on multiple attempted murders. I think that one of those justices would have gone even further and said that in essence that was still high.
That was still too high, right? I mean, so what are you suggesting as the bond?
Well, Judge, there's a couple of routes we could try. Certainly you could set the bond at OR with non-financial conditions to ensure that he's comes back to court and is under lockdown, which would be the safest way, I think, to ensure his right to bail. Alternatively, we could conduct a more in-depth hearing about it. I don't know, I mean, he's locked up in jail with a public defender. I don't know how much
Right.
road to hoe there, but or you could set the bond at some intermediate amount and see if he's able to post that. And then we could address the issue if down the road he's still
Until I work my way down to zero.
if that's the case and he chooses to sit to try to do that.
Okay. What level of offense is this?
Judge, this is a felony in the second degree.
Okay, go ahead.
Judge, we have concerns with this individual being out. Also, even if the court were to look at a bond condition such as EMD, they live in the same apartment complex. So he's never going to be away from her. She's never going to be technically safe from him. If the court would like, Judge, I could ask for maybe even a day continuance. I could file a no bond for a no bond hearing if that would appease the court. We have concerns for the safety of the community as well as the victim in this case. Should he get out, I don't know what his monetary means are, but I have the same concerns as you, Judge, that people could just then come back and say, I can't afford anything. Everybody should be out on an OR bond. And I don't think that was the intention.
But that's where they set it up. That's where they ruled, and I'm hoping that somebody will actually appeal me so they can review it again. To understand, that's how I put everything on the record to kind of point out the errors in their way. Not that I'm challenging the Supreme Court, but there's some errors.
One thing, Your Honor, just to point out, the defendant, my understanding is, does not, I guess it's your mom's place there. She doesn't live there anymore, so if you were out, he would not be going back to that same
Where would he go?
Where's your mom currently?
I'm staying with my sister.
Is she here to tell me that you can stay with her?
No, she's not here.
Although they would check with her before releasing them on juris bond.
Go ahead, I'm sorry to interrupt you.
Judge, I had nothing further to add. Did you want to say anything?
You got it.
We think that the bond is sufficient where it is. Again, he's on probation to for a different burglary. And, we have concerns, we do have concerns with him returning to court as well. So
I don't understand how we cannot consider the safety of the community. When an individual continually commits the same offense.
Well, I would just make a note on that point, Judge. What he was, the burglary, I think that was referenced that he was previously convicted of was actually a trespass and habitation. It is on the same, it's under the same code section as the burglary, but it's specifically listed as being trespassing.
Okay.
And then again, it's just, as I said, it's just a question of how the court has interpreted the law and what this.
Right. And the young lady, the victim was here the last time, and she's very terrified. To have someone in her bedroom and she wakes up and he's playing with her feet. And I think she's very young too.
I think she's 25.
Right. Well, that's young.
Honestly, it's not mine at this point.
Right.
And for what it's worth, Judge, the defendant denies the allegations of it.
Well, I'm glad you brought that up because some other factors that I can consider, again, the seriousness of the offense, ID of the defendant. And I think that the victim at the last hearing was able to positively identify this person as the person who committed the crime. The fact that he left his shoes at the crime scene also points to him being in her bedroom. The likelihood of him going to prison for this charge, this is a felony of the second degree, so I can give him anywhere from 2 to 8 years in prison.
And, Your Honor, about some of those allegations, I would have some points to make on those.
Go ahead.
As it relates to his shoes, when the defendant was questioned by the police, he did indicate that the shoes were his, but that he had thrown them away earlier, I think a previous day, and they were in a dumpster that was accessible to anybody who would come by.
So you're telling me that he threw the shoes away, she went out to the dumpster and got them and put them in her bedroom?
Or the person who did it went out and got them.
Oh, okay. All right.
Ultimately, Judge, I don't know, I don't have any information about where the shoes were specifically found. I'm sure the detective does, but.
He said they were found in the bedroom.
They were in the bedroom.
Yeah, to the bed.
And then, beyond that, Judge, one of the things about the identification, again, I have somewhat limited information at this point. I don't know when the identification was made, but what I can say is that this was alleged to have occurred on August 1st. The defendant was not charged with it until August 25th. My understanding is that he was living there at the time, but that when I'm looking at the police report, which is the only information I have, again, I'm sure the detective can fill us in on more, it's that it was listed as an unknown suspect who entered the room. And then there was an interesting notation on the police report, which states this: victim's description of suspect was only male black with dingy socks with leaves on them. Victim says she yelled for her father in the other bedroom. When the father got to the room, he says he saw the window open but did not see anyone. And he put it back down and pulled the blinds down and put up the cover over the window. When an officer went to check the windows there where the suspect, and it's in quotes, allegedly came through, sorry, allegedly is in quotes, and it says came through. There were no signs of any entry or exit from that window. There was dirt and cobwebs that had not been disturbed. It goes on to say that the screen was down, blinds were down, covering the
Yeah, during the course of the investigation, I questioned the witness a few different times. She gave me the nickname of KG, and then maybe an hour later she came back with
the suspect's name.
Okay.
I asked her what their relationship was there any sexual contact, and she said no, everything like that. How many times you seen him in the course of a few months? Multiple times. Was able to pull the picture up, showed her the picture, and then we went ahead and made the arrest. All right. He was interviewed prior, because on probation brought him in for an interview, but we did not have the ID from her yet to verify this was actually the suspect we were looking for. That came after our interview, and she said yes.
Okay. So you understand where this case is going as far as the Supreme Court case. It's almost like they're forcing me to have a mini trial now to almost determine his guilt as to whether or not we want to release him on bond. Because I have to get so much information about his ID and about the situation that, you know, we just had a mini trial as to, and you heard a lot of the facts and where they're going with their case, correct?
Yes, Judge. And that's actually one of the main reasons that I cited to the Muhammad case, in that they made a note in there that it's not, but the court's role in this sort of how strong a case they have is not to resolve factual disputes. It's only to, I guess, probe to see whether there are any. In the Muhammad case, there was this alibi. The state said the alibi was junk, but there was an alibi. And so they said, well, because there is an alibi, that's something that.
Right.
Anyway, you've read the decision, so.
I don't know if I said it, but I also have to consider his ties to the community.
Yes, Judge.
And he is a resident of
Cincinnati. He's lived here for the last 30 years. He's a graduate of Taft, is that right?
Right. But here's another issue. I don't have anyone here indicating that he can go somewhere other than that apartment complex. Because he's definitely not going to be able to go back to that apartment complex. So if I were to give them, say, the OR bond that you're asking for, where's he going to go? He said he could possibly stay at his sister's, but do I really know that?
Well, so the way I think that could be resolved, Judge, is I think you could say he's not allowed going back to that address. I mean, it's a very simple thing. I mean, if that's the only place that he's got, and then let's say you make it OR with juris monitoring and say, okay, but he can't go back there. And then that's the only place he's got. They won't let him out. He'll just be held on that until another address pops up. As far as verifying where he can go, my understanding of the process, just from dealing with calls from family members and clients, things like that, is that EMD will not just take the defendant's word. They need to contact someone at the address to ensure that he's allowed to go there before they let it go.
Okay.
And then they come out and inspect the address at some point.
And again, just for the record, Mr. current bond.
Judge, current
You told
bond,
it to me once before.
it's $100,000 at 10% juris monitor.
All right, so here's what I'll do. I'll reduce the bond, the monetary portion. It'll be down to 20,000 and 10%, which again is going to be more than you can afford. So you'll be right back here saying you can afford the 20,000 and 10%. Juris monitor, EMD, electronic monitoring, and he is to stay at the address he's going to give me of his sister's address. If he can't stay there, then he will remain incarcerated.
Thank you.
All right, thank you.
Well, yeah. Thank you. I appreciate it.
All right, court is adjourned.